Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated. Case number 22-7047, Devon Tinius, appellant, versus Luke Choi, DC Metropolitan Police Officer, et al. Mr. DeVita for the appellants, Ms. Johnson for the appellees.
Good morning.
Morning.
On June 1st of 2020, the District of Columbia government was concerned about looting, burning, and vandalism in the city. In response, they enacted a curfew, which did not regulate looting, burning, or vandalism, but which in fact criminalized ordinarily innocent activities like walking, biking, and running. The curfew did not contain a First Amendment exception, and the curfew also contained a term, loitering, which no court has ever been able to define satisfactorily. What this court has to determine is whether or not the curfew law is constitutional, because if the court concludes that it is not constitutional, then everything else falls by the wayside. For example, with respect to claims of false arrest, my contention would be that you have to start with a law that's valid. You have to start with a law that's constitutional, because if you don't, there's no authority to act at all. There's no authority to make the arrest. And as a result, it doesn't matter whether the officers were acting in good faith. It doesn't matter whether they claim that their activities were privileged, because they have to have a law which allows them to make the arrest. For example, I couldn't arrest anybody in this room because they don't have the authority. And so any attempt on my part would be illegal, no matter whether I had a good faith belief in its reasonableness or not.
Mr. DeVita, how do you respond to the district's argument that the use of the term loitering in the statute is quite different from its use in other statutes that bar loitering? Because here, it's one of several terms that make clear that it wasn't lawful during the curfew period for people to be out and about for any purpose, except for the very narrow exceptions. And you didn't file a reply brief, so we don't know what your response is on that.
Well, my response is, I think was actually within the brief I had, which is that if you let the police make those determinations, you've essentially created a statute that doesn't give any boundaries at all to what the police can do. For example, the district court.
But that doesn't really respond to their point, because their point is that the precedents that find loitering to be vague are vague because it's difficult for either the members of the public or the police to know when someone is legitimately waiting for their ride versus when someone is loitering. Whereas under this statute, whether you're waiting for a ride, walking, running, driving, or loitering, it's all equally prohibited. So that line between legitimate presence on the street and illegitimate loitering is just not salient under this curfew.
Well, you're right. Once again, the statute doesn't define the term. And if it doesn't define the term, I don't see how you can read in the argument that people should interpret it to mean that you don't have any right to be on the street at all. Loitering doesn't mean that you don't have any right to be on the street at all.
And does this putative vagueness affect your clients at all? They acknowledged they were there under the terms of the curfew after it came into play.
Well, you know, who knows what the police were arresting them for? That was never really specified. And at this point in time, I think the problem is whether you start with a statute that's constitutional to begin with. And there certainly was no, every court in this country that has ever looked at a law or a curfew or any other type of legal, any type of law that had the word loitering in it, has always said it's impossible to define. For example, the U.S. District Court said loitering would mean lagging behind. How do you determine when somebody's lagging behind? What's the time amount that you're supposed to be on the street? If you stop to look at a store, are you waiting too long? The long and the short of it is, they can't. The district court and the government cannot read into the word loitering the idea that people who are not trained in the law should automatically assume that that means that you can't be on the street at all. Who knows what loitering is? And that's really the problem, is that if you leave it like that, you leave it up to the police to make those decisions. And the police may very well look at somebody who's out in the street, decide that they don't like what they're saying, and say, well, he's been on the street 10 minutes. He's loitering. Well, what if he's on the street 5 minutes? Would he be loitering? 15 minutes? Is that loitering? It's just, it's completely undefined. And that's the basic problem what the courts are trying to prevent is a statute that's that vague that leaves it up to the police officer to decide who he likes or who she likes, who they don't like, who they want on the street, who they don't want on the street. If it's completely vague, the police can do anything they want.
May I ask you a different question? So you are challenging the constitutionality of this curfew order.
Yes.
And with respect to your First Amendment claims, the defendants are the individual police officers. And so I'm wondering why the District of Columbia is not a defendant since you're challenging the curfew order, and if there are any precedents that adopt the same procedure where you're suing individual police officers when you're challenging the constitutionality of an order like a curfew order.
Well, first of all, under 42 USC section 1983, in order to prove that the city is liable, you have to prove that the actions were the result of custom, policy, and practice in the city. And I just don't think that applies to this situation. The city is a defendant with respect to the common law, right, because they have responded at superior liability. But
I'm puzzled by that. This is their policy. They adopted the curfew as official policy of the city, no? The mayor adopted it.
Yeah, I understand that. That's a good question. To be honest with you, ordinarily in situations, I've always sued the police officers simply because they are the individuals who are acting. As long as they're in the case, it seems.
And I take your point to be that even if the way you framed the case, it couldn't invalidate the curfew. Your point is that it didn't extend authority. It didn't constitutionally extend authority to the arresting officer.
That's correct, Your Honor. And I only think of custom, policy, and practice in terms of actually habits that the city engages in. For example, if there's a pattern of arresting people without for excessive force, I wasn't considering it in the light that you were talking about. But I think the.
But then don't you run into the problem of qualified immunity?
Well, that's what I was trying. That's what I was trying to address at the outset, which is that I think that you have to have two steps here. The first step is, did they have any lawful authority to do what they were doing at all? For example, I can't arrest anybody in this room because I don't have the lawful authority to do it. And so no matter what I do, anything I do is illegal because I don't have the lawful authority to act.
But it has to be clearly established.
Well, not only that, but you have to start off with a law. There has to be a law. And if the law is unconstitutional, it's void from the moment it was enacted.
But how are the police officers supposed to know that when they're out enforcing a curfew order?
And that's another good question. So the question becomes, let's say these officers were acting in good faith. Let's say they reasonably believe they were enforcing the law. The problem is that if you let them assert that defense, it leaves my clients without redress. If you take a look at the Yale College decision here, which I cited, which took me a long time to find, it's really old law. But what the court said in that case is that you just can't allow the public officials to escape liability because it leaves somebody who's had their constitutional rights violated without a remedy. And I think that's the basic bottom line here, is that if you don't start off with a law, you don't even get into reasonable good faith. You don't even get into privilege. You have to have a law in order to be able to act at all. And I think the Yale College decision, as I mentioned, is on point, and it basically holds that you can't allow the public, you can't allow the government, you can't allow the police to escape liability for their actions if they're acting with respect to an invalid law.
But that case predates Harlow, Anderson versus Creighton, all of the Supreme Court's contemporary qualified immunity doctrine, and the courts do grapple, as you mentioned, with the question when and under what circumstances are members of the public entitled to redress, but it's under a rubric that postdates Yale College.
Yeah, well, old doesn't necessarily mean invalid. I'm 64 years old myself, but more to the point, I I don't think any of the decisions she's talking about dealt with unconstitutional statutes.
All right, we should move on and hear from
Oh, I'm sorry. Thank you.
other counsel. Did you intend to reserve time?
1 minute.
We'll give you the 1 minute. Now we'll hear from Ms. Johnson.
Good morning.
If you want to change the height there, it's over on the right. And it actually helps us hear the more direct the microphone is in front of you.
Thank you. Good morning. May it please the court. Holly Johnson for the District of
Pull
Columbia.
that, Mike.
You want me to move this one this way?
Yeah, thank you.
Is that better? Thank you. In 1979, the Supreme Court held that probable cause is not defeated by the unconstitutionality of the law. And I want to be clear, by no means are we conceding that the curfew was unconstitutional, but this was where the court left off. So I want to start there. And what the court said there, the Supreme Court said, is that the police must enforce laws until and unless they're declared unconstitutional. And pointed out all of the risks and dangers of having the police decide whether they think a law is constitutional to enforce it. So probable cause itself, even if this court were to find that the curfew was unconstitutional, would not be defeated by that finding. But even beyond that, in Letterman, this court held that even an astonishingly broad unconstitutional law, it was a ban on demonstrating on the Capitol sidewalk, so it was a First Amendment case, that even that, the enactment of the law foreclosed speculation of the police officer regarding the constitutionality. So even that astonishingly broad, and according to this court, plainly unconstitutional law, still the officer was entitled to qualified immunity with regard to the arrest because it had not been declared unconstitutional. The standard for qualified immunity is whether a law is clearly established. So all of the constitutional claims here could easily be disposed of via qualified immunity. I don't know that that's the direction this court wants to go, or whether that's necessary.
I'm curious about what you think would be the better course. We always have a choice in a case such as this where there's a qualified immunity assertion on officials' part, whether to go the Saucier Pearson route, and under those cases, whether to decide the merits or whether to assume the merits and decide qualified immunity. Do you have a argument as to which course we should choose?
I think there could be some benefit to a ruling on the merits on the First Amendment for purposes of clarity going forward. There's no doubt that the mayor at some point in the future will have to declare a public emergency again. It's entirely possible a curfew would need to be declared either due to a natural disaster or civil unrest. So it would be nice to know the court's position on that. With regard to this, we believe completely forfeited claim regarding intrastate travel, or even with regard to the loitering thing, we don't think those are substantial enough arguments to require anything beyond a qualified immunity holding. And of course,
when you say with regard to the loitering, I thought that was the First Amendment, but I thought that was the only other constitutional argument, or I guess tailoring.
Tailoring would be, the loitering is a vagueness argument. Yes, suppose that. Well, my understanding is that vagueness comes under due process, so that would be a Fifth Amendment claim. It's not really clear because all of these fell under the rubric of false arrest, so you sort of had to parse out the amendment. So there's a First Amendment claim, just a very straight up claim. The district does not dispute that there was an infringement on First Amendment rights and that some level of heightened scrutiny would be warranted. We believe that the appropriate level of scrutiny would be the Chalk and Smith line of cases, because this was a public emergency, and would obviously prefer that this court highlight that as a possibility. But we focused our briefing on intermediate scrutiny because that's where the district court landed, and because we think that this rule survives intermediate scrutiny with flying colors.
So can you talk a little bit about that? Because the one thing that I see that gives me some pause is that this was a curfew for the entire city.
Yes.
How is that tailored?
Yes. So I want to just lay a marker and say that we believe that even under strict scrutiny, this would survive, but I will focus on the tailoring required under intermediate scrutiny because this was a content neutral law. Under intermediate scrutiny, first, for the legal standard, it doesn't have to be the least restrictive means. It just has to be a means where it would be less effective absent the restriction. And there are very good reasons to do a district-wide curfew in a situation like this. The undisputed facts, and they're alleged in the complaint, is that civil unrest dangerous civil unrest was happening all over the district. And so there was no question as to where it was going to pop up. If this court looks to the Jeffries case cited in my brief, it is a district court case, but it's from the city of New York. It involves a curfew, I think the same weekend, the same events, so it's very similar. And in Jeffries, and I think Jeffries applied strict scrutiny, the court pointed out that the rioting and violence and vandalism was taking place in different boroughs. Not every single street, not every single borough, but because it was popping up in different areas, it was perfectly reasonable to do a citywide curfew for the brief period of time for those 2 nights.
What about the lack of any carve out, any sort of First Amendment demonstration area could have been policed and localized away from businesses and other buildings subject to looting?
So the First Amendment carve out, I want to, if I can take a moment to before I respond to that, because I do want to point out that the practical reasons for a district-wide curfew are really important. The last thing that the district wants to do is to push the violence and destruction out of the middle of the city and into the residential areas. And there could be some real equity concerns with regard to that as well, as to which parts of the city are shut down. It could cause racial imbalance. So there were a lot of reasons not to do that.
Well, is that in the record, or is this something that needs discovery?
It doesn't need discovery because it's clear and straightforward. If you look at, like the Jeffrey case sort of gives you examples of how this works. If you look at the purposes of the curfew that are listed in 1C, which is a California case coming out of the Rodney King protests. I mean, in answer, and I apologize, Judge Pillard, I do want to get to your question, but in answer, in the one regarding the event signs, this court held that you don't need evidence where there's a straightforward line of reasoning between the means and the ends, and that the quantum of evidence needed will vary with the novelty and plausibility of the justification. A curfew in response to rioting is not novel. It is a very standard approach. It's very plausible that that's how you restore peace and order.
So I guess my follow-up would just be then, where in the complaint, or you're saying it's undisputed that the rioting was all over the city. Where can I find that?
So there's a couple places. First of all, in the complaint itself, if you look at JA 35, the plaintiffs allege that the mayor's order cites the fact that numerous businesses, vehicles, and government buildings had been vandalized, burned, or looted, and that rioting had occurred in, and it lists all these areas across the district. So that's in the complaint itself. But beyond that, the complaint incorporates the curfew orders. And there's been no dispute on the part of the plaintiffs that those are properly incorporated into the complaint. This court's rules and the district court's rules allow for incorporation of documents. And the curfew orders, I would say probably the best place to look is JA 32 and JA 31, like details everything that had happened in the previous nights and explains that these were not isolated incidents. More than 80 arrests took place in the 2 nights preceding this curfew, and more than the majority of those were felonies. So this was a very serious circumstance. The other reason we know that it was serious is that the mayor declared a public emergency, and there's a statutory standard for that as well.
So if I may, though, like looking at the language that you're citing, it says northeast, northwest, stretching to Georgetown, Golden Triangle Business Improvement District, downtown DC Business Improvement District, and the Mount Vernon Triangle Community District. There's a lot of DC that's not included in here.
That's correct.
Southeast and southwest.
Well, first of all, I mean, yes, I mean, this does not list in detail everywhere. But again,
I'm just talking about narrow tailoring. It's supposed to be related to where the problem is. And if the problem's not all over the city, why is this curfew covering the entire city?
Because the risk of pushing the rioting out into other neighborhoods.
And where is that in the record?
It's not, it's common sense. And I understand we're working on a motion to dismiss here.
That's what I'm saying.
And we will also note, and I think this is important, that this is not an argument that the plaintiffs have raised. The only tailoring that they propose, and it is their burden to propose the alternatives, the only tailoring that the plaintiffs propose is a First Amendment exception, which is the question that I've been making Judge Pillard wait for. So I'm going to turn to that now. The problem with the First Amendment exception is that when the danger arises out of people who are purporting to be out there exercising their First Amendment rights, there's no line between the would-be wrongdoers and the the protesters themselves. So that's the first problem. I will note that there are no examples or cases or anything cited by the plaintiffs in which an emergency curfew had a First Amendment exception. The First Amendment exception always comes into play with permanent curfews, not with these emergency curfews or with permanent restrictions on certain activities. The second thing I would point out is that the First Amendment exception would not protect the protesters. And if you look at 1C, one of the purposes of the curfew during a time of civil unrest is to protect the innocent people who are out there, to make it clear that when they are out there, they are safe, and when it's not safe, they come inside. And also, if this court looks at Menotti, that's...
Why wouldn't it protect the protesters? You put them in a place where they can be adequately policed. You localize the number of people and the nature of the activity that's permitted outside.
So again, the plaintiffs have the duty to propose so that we can properly respond to alternatives, and no one's ever proposed a zone in which there was a safe and controlled protest.
Well, one of the other things the city was asserting was that this was during a period of COVID and they did not want collections of people. I mean, you're jumping right back. It's right in there, right in the order.
It is. That's a really good point.
It's
Yes.
not just that there might be a spread of the bad behavior, but there was a problem of encouraging the spread of people that was prohibited. Gatherings of 10 people or more was already prohibited.
Of course, I appreciate you raising that. That's another reason it's in the record, and certainly corralling up all the protesters into one location and creating like a protest zone. But again, that's not an alternative that's been raised by the plaintiffs here at all.
They argued that it was unconstitutional for want of a carve-out.
Yeah, the carve out, but not a carve out in which there was a safe. I'm talking about specifically creating one location. Now, if there was a carve out that allowed First Amendment activity to go on everywhere, then you run into the problem the police had during the WTO protests, which is pointed out in Menotti, which is that the protesters, by no fault of their own, got in the way of the police. They hindered traffic, which made it so the police couldn't respond. And the people who were intent on violence used the protesters kind of as human shields. They would merge in and out of the protests. And so if you imagine, just from a practical point of view, a police officer encountering a group of people, and maybe they're intent on joining a riot, they encounter this group of people and they tell the people that, those people say, well, we're protesting, First Amendment exception, and they go on their merry way. Well, there's no way for the police to enforce that. So it just would have been impractical.
All right. You had a sentence to wrap up I see your time.
I'm good? Thank you.
Thank you, Ms. Johnson. Mr. DeVita, I think we ate into your rebuttal time, but you sought to preserve a minute, and it looks like we will give you that.
Democracy can be a fragile thing. It's dependent on people being able to exercise their First Amendment rights. My clients weren't criminals. All they were doing was protesting what they believed to be police brutality. This curfew law is unconstitutional for several reasons. First of all, it's overbroad. Secondly, it's void for vagueness. The District of Columbia knows how to create a curfew that has a First Amendment exception. If you take a look at the Waters versus Barry case or the Hutchins case, we have precedent in this court, the U.S. District Court. In the first case, they found the law to be unconstitutional, or found the law to be constitutional because it did have an exception, and in Hutchins, it did not. The long and the short of it is, there should be an exception in the law for First Amendment activities. Otherwise, governments can use a curfew law to curb speech that they simply don't like.
Thank you. Case is submitted.
Near this area. Judge Phillips.
Case number 21-1797, Keren Kayemeth Leisrael, Jewish National Fund et al., appellant, versus Education for Justice in the Middle East, doing business as U.S. Campaign for Palestinian Rights. Mr. Lewin for the appellant, Ms. Shamas for the appellee.
Morning, Mr. Lewin. You may
Good morning.
proceed when you're ready.
Thank you. May it please the court, this is an appeal from a dismissal by the district judge of a complaint under the Anti-Terrorism Act, 3 claims made on behalf of American citizens residing in southern Israel, and 3 common law claims made on behalf of Keren Kayemeth Leisrael, which is the fund that plants trees in southern Israel. And the district judge dismissed the complaint, all 6 claims, and the grounds that he stated for dismissal are clearly, in our view, reversible in light of this court's decision in the Ashley case, which certainly involved very gross violations of the anti-terrorism statute. Indeed, it appears to us that this is a case which follows a fortiori from the reversal in the Ashley case, because in Ashley, the defendants were pharmaceutical companies that were alleged to have participated in violations of the Anti-Terrorism Act, both direct and aiding and abetting provisions, but they were major pharmaceutical companies. In this case, the defendant is an American 501c3 entity which takes contributions and which end up being tax deductible and sends the funds to entities that clearly are associated with foreign terrorist organizations like Hamas and have a much closer relation in terms of.
May I ask you about that, Mr. Lewin?
Yes.
So I understand your complaint to be alleging that, I'm calling it USCPR, donates money to the BNC, and that the BNC has a member, which is the PNIF, and the PNIF has members that are foreign terrorist organizations, including Hamas. And I'm wondering what your theory is as to BNC. USCPR gives money to BNC. Is your theory that BNC is an intermediary to terrorist organizations, or that BNC itself is a front for Hamas?
Well, we do say, and the evidence, of course, that will be available and we hope will be established in the way of discovery would be that BNC would itself be a front for Hamas. But
so your theory is not an intermediary theory. You're like in Ashley. Your theory is in Ashley they decided it was a front for terrorists. But your theory is that it's not an intermediary like a bank, for example. That, but your theory is that BNC itself is a front for Hamas, and therefore it's like Ashley and Boehm, that it's a direct contribution of funds to Hamas. By giving to BNC, they're giving money to Hamas. That's your theory?
Yes, that is our theory. But the point is that, as we try to make in our brief, that these are matters that are very carefully concealed by those who are engaged in terrorist activities. Although we think it is a direct front for Hamas, it is a matter of discovery. We should certainly be entitled to proceed with the allegations of the complaint in order to determine precisely what BNC is and what it does.
If you could just tell us then, what are your non-conclusory allegations in your complaint that would establish that BNC is a front for Hamas?
Well, the non-conclusory allegations are the membership of BNC, what its activities are, what its goals are. We allege that its goals are the destruction of the state of Israel. And
but you also allege that it is an entity with a single objective, the realization of Palestinian rights, and that it is an organization that argues for freedom of expression, for the right to demonstrate. And so the relationship between that and the goal you ascribe is not
Clear.
It's not necessarily on its face plausible.
Well, in lots of ways, that's like the Holy Land Foundation in the Boehm case. When we made the allegation in the case that we brought against the Holy Land Foundation, the Holy Land Foundation claimed that it was also engaged in substantial charitable activity and not just in financing Hamas. Now, ultimately, we went to trial in that case. But the fact is that at the time the complaint was filed, the Holy Land Foundation, which was then a very generally accepted charity, was claiming that it was engaged in other activity beyond the violations of the Anti-Terrorism Act. And our point is that we should be able, on the basis of a complaint that has been filed in this case, and if one looks at the actually opinion and the very standards that the actually court laid out with regard to sufficient allegations under both direct liability and aiding and abetting liability under the Anti-Terrorism Act, that in this case, we have more than adequately met the standards in that case. Now, I see I'm into my rebuttal time.
The other way to look at this is not actually because the allegations of proximate cause were much clearer there. It's more like Owen. And you just don't show the connections in your complaint in a way that we saw and it appears to be like what we were looking at in Owens, which was insufficient.
Well, again, this case cannot, we submit, be compared to those in which the claim is made against substantial financial institutions which engage in lots of other activity which is not necessarily connected to the focus of what the terrorist organizations are designed to achieve. I see I'm into my rebuttal time, and I'd like to reserve that if with the court's permission.
All right, we will grant you some rebuttal time, and we'll hear now from Ms. Shamas. Shamas? Morning.
Good morning.
If you wanted to bring it down just a couple of inches, if you look down.
If you can hear me,
There's a button.
Yes, this is a good height for me if you can hear me. Okay. May it please the court? My name is Yala Shamas with the Center for Constitutional Rights, or APALI, the U.S. Campaign for Palestinian Rights. The U.S. Campaign for Palestinian Rights, also known as Education for a Just Peace in the Middle East, is a human rights organization that, according to plaintiffs' own allegations, and as the court pointed out today, engages in advocacy for Palestinian rights. To connect this advocacy to terrorism, plaintiffs have weaved a series of attenuated connections which they attempt to bolster with inflammatory, politically charged insinuations. Now, it bears repeating, and let us be clear about what their theory of liability here, and I'm repeating Japan's characterization of their allegations. Plaintiffs are proposing that the U.S. campaign, by being the U.S. fiscal sponsor of the Boycott Committee, which is a coalition, quote, one member of which is itself a, quote, coordinating framework of multiple political factions, one of which is Hamas. Plaintiffs provide no factual allegations that any support to the boycott committee via that fiscal sponsorship went beyond the boycott committee. In fact, there are no facts indicating that funds collected via the fiscal sponsorship even left the United States. Let us be clear, there are only
But
two
I think
actions.
the boycott committee is located in Israel. So
The boycott,
so if the campaign is collecting money for the boycott committee, it's leaving the United States, no?
well, Your Honor, actually the complaint refers to a US-based representative of the boycott committee, and it doesn't refer to any movement of money or other resources across borders. And there are only two actions that the US campaign allegedly engaged with here, and it bears really underscoring them. So the first is the fiscal sponsorship, which we have discussed starting sometime in at least 2017. And the second is that the US campaign tweeted and emailed its supporters in support of the rights of Palestinian marchers in Gaza, including condemning the killing of 14 Palestinian protesters during those marches, during the first week of those marches. That's it. There are no other allegations about the fiscal sponsorship, about what that entailed. The only other allegations of support are allegations like, quote, working closely with the boycott committee and partnering with the boycott committee. And that's in complaint 128 and 130. There is nothing else, Your Honor.
But Ms. Diallo, there is a bit of a catch-22 for plaintiffs in situations where they don't have full access to the details of the relationships among the different entities and people. And so why isn't it at least a plausible inference from the complaint that, yes, the money was going overseas to the boycott, and if the boycott had significant representation by this other coalition, and they allege that Hamas had a leading role and a large voice in the boycott, and in order to really pin that down, wouldn't it be, or why wouldn't it be appropriate to allow some discovery into the particulars?
Thank you, Your Honor. And this gets to the question, well, first of all, plaintiffs still need to meet their basic pleading allegations, and they have to provide some factual basis for their conclusory allegations. And the crux of the question is one that this court put to Mr. Levine, which is, what is your theory here of the relationship between the Boycott National Committee and these various other intermediaries? And let's be clear, there are here at least two, if not three, intermediaries that are alleged. One is the Boycott National Committee, the other one is the PNIF, and then the other one is Hamas. But, you know, and each one of those, they don't allege requisite control or domination, or to use the Bernhardt language, you know, the close intertwinement. Any of those theories are not really applied here. To be clear, the Boycott Committee is a coalition. The only allegations about what, you know, the relationship between the Boycott Committee and the PNIF is that it is a member of that coalition. Membership is not control. Membership is not domination, as it was of the Jaish al-Mahdi in the ministry in Ashley. And similarly, if you look at then the next degree of separation, the PNIF is itself alleged to be a coalition.
Although just to be devil's advocate on this, if Hamas is the controlling power in Gaza and the boycott is standing up for the rights of people in Gaza, Palestinians, to demonstrate and to speak and to have civil rights, civil liberties, why isn't it a fair inference that they and or their proxies would have an outsized role in the boycott, the stated objective of which is to boycott Israel for what it sees as failure to respect the rights of the Palestinian people in Gaza?
Your Honor, simply there are no allegations in this complaint, factual allegations or supporting factual allegations to support that inference. There is no allegations that there's a connection between Hamas and the Boycott National Committee. the only allegation connecting the Boycott National Committee is to the PNIF, and that is membership in a coalition. And then with regards to the allegation that Hamas, to the theory that presented by plaintiffs, that because Hamas controls Gaza, anything that happens in Gaza is somehow attributable to Hamas. So even if this court were to infer some kind of connection between the Boycott National Committee and something occurring in Gaza, that theory has no basis in law. Plaintiffs rely heavily on the Boyne Seventh Circuit decision, and even in that decision, the court clearly found that support to a hospital in Gaza that is not alleged to be connected to Hamas is not amounted to support to Hamas. Again, here, this court offers a lot of guidance in its Ashley decision about the kinds of allegations that there showed domination and control of the ministry by Jaish al-Mahdi, which was the group there that was involved or responsible for plaintiffs' injuries. They alleged 70,000 employees of the ministry were members of Jaish al-Mahdi. They showed that the ministry, the allegations that this court pointed to, are that the ministry was fully controlled by, if you walk through the halls of the ministry, you would have seen posters of Sadrists, you would have seen fighters walking the halls. It was dual purpose. The hospitals were used by Jaish al-Mahdi. I'm sorry, Your Honor.
I was just going to ask you, because two members of this panel were on that case, so we're well familiar with the facts of that case. But I just wanted to press you on sort of what is and isn't pleaded in your view. And in particular, I take it that it's adequately pleaded that the campaign was aware that the Great Return marches were sometimes used as sort of the launching place for the incendiary kites and balloons. There was awareness of it.
I don't believe so, Your Honor. The only tweet referencing kites and balloons is, I believe, on referenced and reproduced in paragraph 134 of the complaint. And that references kites and balloons from Gaza, not even from the Great Return March. But in any case, in any event, the U.S. campaign's tweets about the Great Return March only indicate support for protesters' demands of human rights and criticism of Israeli use of lethal force against unarmed protesters, and those are their words. Your Honor, just to underscore, and I see I have a minute left here, to the points on the speech that is alleged to the plaintiff's allegations here about our client's speech. It makes it clear that this case is about punishing the U.S. campaign for its advocacy in support of Palestinian rights and boycott, which the complaint repeatedly equates in conclusory terms with terrorism. There is no factual support for that egregious and extreme allegation. Plaintiffs make their hostility towards the U.S. campaign's advocacy clear, and that is not enough to grant them, that is not enough to state a claim, and not enough to proceed with their harassing litigation against the U.S. campaign. There are no further questions?
Thank you.
Thank you.
And we'll hear again from Mr. Lewin, who had sought to reserve time for rebuttal.
Yes, Your Honor.
Right, we'll give you 1 minute for rebuttal, Mr. Lewin.
The complaint's allegations very specifically describe how the incendiary balloons, which are a terrorist mechanism that has affected American citizens, 3 American citizen families, were not only supported, but really part of Hamas's Great Return marches that were celebrated for the release of those incendiary balloons. And we think the complaint has adequate allegations of not only the direct liability under the Anti-Terrorist Act, but certainly under the standards of actually for the aiding and abetting provisions under JASTA. And consequently, we believe that the decision below should be reversed in light of actually. Thank you.
Mr. Lund, for your direct liability claim, there has to be that the defendant proximately caused an act of international terrorism. And I take it that the act of international terrorism that you allege is 2331-1, violent acts or acts dangerous to human life. Is that correct?
That's correct. The incendiary balloons, according to the allegations of the complaint, have threatened the lives and certainly caused great mental anguish to 3 separate American citizen families living in southern Israel, and consequently are basis for liability under the direct liability provisions of the Anti-Terrorism Act.
And it's material support to terrorists, or is it material support or resources to designated foreign terrorist organizations? I take it has to be material support to terrorists because the campaign, the boycott is not a designated foreign terrorist organization.
No, it's material support for terrorism because the American tax laws, I mean, the astounding thing about this is that contributors who give funds for this to the defendant are able to take tax deductions under 501c3.
I understand that context. So the question about for the direct liability, if it's under 2339A, little a, then there are criminal penalties for if the supported terrorist commits physical violence with the intent to cause serious bodily injury to a national of the United States. Does that mean that for proximate cause, it has to be foreseeable, not only that there's bodily injury to persons, but that the persons injured are a national of the United States? How do we address that?
I think that under the facts of this case, it would be foreseeable that there would be injury to nationals of the United States because it is, I think, well known, and we can certainly establish at a trial that there are known to be American citizen families living in the area to which the incendiary balloons are released. And consequently, those are not only harmful to Keren Kayemeth and to the forests in southern Israel, but also have a direct impact on American citizens residing in southern Israel.
Thank you, Mr. Lewin. The case is submitted.
Thank you.